Good afternoon, everyone. Good afternoon, Council. Advocate Skosana.
Thank you, Madam Chair, and the panel for giving us an opportunity to confer. Madam Chair, before addressing the issue, and I believe I'm going to be short on the issue of the witnesses, it has been indicated to me that Advocate Harley, SC, would like to address the panel as well, particularly on the issue of the conflict of interest, insofar as the resolution of that question may require up to a week, up to Monday next week. I will leave that to the panel, that issue. But on the question of witnesses, Madam Chair, the answer is simply that as evidence leaders, we had a plan. And firstly, the plan was that we were going to deal with the issue of the Katomena and the witnesses. And on that basis, I personally requested to be excused from this inquiry, to go and consult with some of those witnesses. And I consulted with one of them. One must remember that these witnesses are of high-ranking officials, advocates, most of them. One of them I consulted for not less than 12 hours. And thereafter, that was now before the adjournment on the 15th of December.
Sorry, Council, the witness you consulted with, was it in relation to Katomena or the matter?
The Katomena, Madam Chair, yes. And our plan was that we wouldn't like to deal with witnesses haphazardly. Call a witnesses in relation to Katomena and then the next in relation to the Mdluli case. But then I consulted with that first witness, and thereafter, on the basis of what I had been told, prepared a statement, which was not a short statement, of at least 20 pages, and provided to the witness, who then informed me that it's going through the statement and we're now in the thick of the festive season. And later on, I also consulted another witness who had been allocated to me to deal with that witness. A second witness who we could not physically meet over the festive season, but I held a consultation over certain aspects with him, with the understanding that we'll continue with the consultation in the beginning of 2026. Now, the first witness that I consulted with, after a while, I think it was about over 2 weeks, returned to me to say is not happy with the statement, and she requires an opportunity to prepare her own statement. That being the case, and
she needed an opportunity to
prepare a statement of her own, yes, and provide it to me to be able to settle it, and then we could finalize our consultation. Also, one must remember that we needed to provide statements to the team of Advocate Chauke.
And these witnesses, as you said, are high-profile witnesses?
Yeah, witnesses, yeah. They are advocates in the NPP's office.
Yes.
Yes.
So she is an advocate. She could prepare her own statement.
She could prepare her own statement, and which days passed, and I made follow-ups as much as I could. Where is your statement? is not coming through, is not coming forth. That and I'm giving just a broad overview of what happened. That was now up to last week. It is only on Thursday, to our greatest surprise, that the witness informed me that she is not prepared anymore to testify. And she gave us the reasons for doing so. She gave us a statement, quite a long statement for us to go through, some report that she had previously prepared for the office of the NDPP. Now, that was now Thursday last week. And on Friday, I also received a WhatsApp message from the second witness, who informed me again that because of his commitments, in short, because of his commitments, or the commitments that he has made this year in his life, the studies, and he counted a number of things, is no longer prepared to testify in this inquiry. And which we conveyed, I conveyed to the team. So, in essence, our plan, and these two witnesses, I must mention that in terms of our estimation, the first witness would have taken our estimation about 8 to 10 days. The second one, 6 to 7 days. And we had contemplated that in the event Advocate Batohi does not return, we would be able to cover that period. And the rest of the colleagues, during their testimony, the testimony of these witnesses, they would be going out, they would be excused, just like it happened to me, to go out and consult with these other witnesses so that the proceedings are not interrupted. We can proceed with the case. I also want to mention that Advocate Mohlabonyane SC, on the other hand, was also consulting with a different witness who also would, according to our estimation, would take about 10 days to 15 days. That's our estimation of the testimony. And received a message from his attorneys that the witness will not be able to testify.
His attorneys, are you referring to Advocate Mohlabonyane? His attorneys.
Sorry, the attorneys of the witness, who has separate attorneys. So we were informed that they need to consult with this witness, prepare the witness, and in what they are doing, the witness will only be available to testify towards the end of February 2026, in this inquiry, because they want to make sure that they secure the rights of their client.
If I may ask, is that Major General Boyson? Because I saw a letter from an attorney which expressed sentiments to that effect. Is that the Attorney Kun? Is that attorney?
Madam Chair, Madam Chair, you are right on the point, yes.
Well, that takes us to the third witness. You've spoken about two witnesses.
To
this
the
one
third witness,
is the third witness.
I am informed that the witnesses, and that would take about two more, well, I think three, in the Katomena one, who my colleagues, we allocated each other, one another. They had difficulty getting hold of the witnesses in the first place during the festive season, some of whom were not prepared to meet them during the festive season.
Are you speaking for or on behalf of Advocate Mchweni, for instance? I remember at one stage last year, he asked that he be excused to go and consult. Are you speaking on his behalf as regards when you say my other colleagues?
I'm speaking on behalf of Advocate Mchweni and Advocate what's his name? Sorry, Madam Chair. Yeah, I'm used to the first name.
First hear what the position is with regard to Advocate Mchweni, because I remember he had to be excused last year to go and consult with the witness, and what has happened with regard to that consultation. I just want to establish whether the evidence leading team has prepared witnesses for us to proceed. And if there are challenges, precisely what are those challenges?
Yes. Yes. Madam Chair, maybe to also add or to clarify is that as far as the witnesses relating to the Mdluli case, must be honest that we had not consulted. And the plan of the evidence leaders was that that would take place once we see we are towards the end of the case relating to the Katomena. And would like to also emphasize that what has really disturbed us and put our plan off track is what happened last week, because with the two witnesses. Because had that not happened, we are sure that we would be able to proceed, even if in the light of this postponement that we're asking for with those two witnesses, and they would take time long enough for the other issues to be resolved that we are dealing with regarding Advocate Batohi.
But let's get to the specifics. How many witnesses did you list in the list were to testify in relation to the Katomena matter? Because you have spoken to two witnesses who collapsed that you had consulted with, and the third witness who is supposedly collapsing is Advocate Boyson. We have seen the correspondence.
Yes.
There are other witnesses in your list as regards the Katomena matter. What is the position in relation to those witnesses? You mentioned that your colleagues have not been able to consult. In relation to which witnesses were they not able to consult? Pardon, yes, sir. I'm sorry. In relation to which witnesses have your colleagues not been able to consult?
Madam Chair,
in relation to the Katomena matter?
The Katomena matter, because we had resolved and planned that would deal with those witnesses and be able to conclude that. And the consultation in relation to the Mdluli case would take place when we see that we have covered the Katomena, and towards the end of it, of course, would ask for an excuse of some of the colleagues to go and consult so that there is no interruption. But
how many witnesses were allocated to each one of you?
I personally had how many? At least 3. Yeah, but I must indicate that for this period, I was focusing on the witnesses that I was going to call.
So you consulted only with 2 witnesses who have collapsed?
We have collapsed, yes.
The third
as
one?
Of last week. The third one I had not consulted with. I had not even had an opportunity to do so because my focus was on the 2 witnesses. And one would appreciate that the issues of and information on this matter is quite involved, and my focus was on them. I have not yet consulted with the 3rd witness.
Advocate Mchweni, how many witnesses?
2 in the case.
Thank you, Madam Chair. Chair, according to the record, to the allocation, it was 2 witnesses.
And what has happened with your role?
No, in fact, it's 3, Madam Chair. I apologize, it's 3. Yes.
How many have you consulted with? How many have you consulted with?
Chair, I've not been, I'm going to be honest, I've not consulted with either of them because the idea was that we would, once we resume, the idea was I would have been excused to consult with them so that we can prepare the statements. Their evidence is not long, so I anticipated that within a week or 2.
Please speak to the microphone.
I had not consulted with either of them at this stage because the idea was us to, we're still familiarizing ourselves because, like, for example, there's an officer here whose evidence is interlinked with both the Ngcukaitobi and the Mdluli matter. And due to the voluminous nature of the papers, one had to start familiarizing themselves with myself with the Ngcukaitobi, then use the festive season to familiarize myself with the Mdluli matter. Then the idea was, once the hearing resumes, I would then ask to be excused so that I can go and consult with them, prepare the statements. And the anticipation was that it would not have taken me more than 2 weeks to finalize their statements. So hence, I had not consulted with them. But the idea was that I was not going to sit here throughout the evidence of Ms. Batohi or these other witnesses.
Last year, you asked to be excused to consult with some witness, if my recollection is correct.
Yes, at that stage, the idea was between Advocate Nkosana and I, was that we would share the 2 witnesses, Advocate Noko and Mlojo. But because Chair refused that I should be excused, and hence Advocate Nkosana had to also consult with Advocate Noko and Advocate Mlojo. But the idea was that we were going to share the 2 witnesses together.
If my understanding is correct, on the division of labor, not much has been achieved by the evidence leading team. And I'm saying this with the greatest of respect, but look, we are now on the 4th month, or if I may say, the 3rd month or the 2nd month, and we are still talking in terms of we have not consulted with witnesses.
Chair, unfortunately, but what one can't lose sight of the fact is the stage at which we came into the matter.
I beg your pardon, sir?
I'm saying, in as much as that is correct, sight should not be lost of the stage at which we came into the matter. We came into the matter when the hearing had resumed, and we were expected to, amongst others, familiarize ourselves with the papers, also be here to assist the evidence leader during the leading of the evidence. So the only time that we had so that we can focus and delve into the papers was over the festive season, because the last 2 weeks, the 2 weeks that we came into the matter, we had to be here, and at the same time use the after hours to read through the papers.
Now, I'm sorry, of the 3 witnesses, who could be ready to start in due course? Have you started? Maybe it's a fair question. Have you started?
Chair, no, not yet, but I can start immediately. And depending on the availability, I can try and be ready within a week.
I'm not trying to dictate how you should run your side of the matter.
I appreciate that, Chair, but
But,
at the end of the day, I have a role to play here, and if that role means that I have to be dictated to, I would welcome the dictation.
I can't dictate to you. You are here to gather evidence and present it to us.
Yes, that's what I'm
We don't even
saying.
know who are your witnesses are. You've just given us a list in December. And you expect that you would have gone out of your way to try to ripen this hearing.
I appreciate that, Chair, but hence I do not want to be seen to be giving excuses. But also, Chair, one has to appreciate that it was festive season. Some of these witnesses had their holidays planned. And one couldn't just give them a call over Christmas holidays and say, hi, can you avail yourself for a consultation? One had to respect that as well.
Yes.
Yes. So had it not been, but if it did not have a festive holidays in between, the criticism would be justified under the circumstances, Chair.
Are you saying the criticism is not justified?
Not necessarily, Madam I'm just saying that maybe, okay, I'm lost for words.
It is not even a criticism. It's a fair statement
Yes.
from the bench.
Which I appreciate.
I think you must withdraw that.
I withdraw the statements and criticism, unreservedly so.
Yes, thank you. Yes, thank you, Ramchani. And the junior counsel, were you allocated witnesses to consult with?
Yes, Chair. I was allocated 2 witnesses in the Mduli case, and 2 weeks ago. And I also must say that because I came at a very late stage just before the adjournment, I had to go through the record and familiarize myself with it. And I used the December holidays to do just that. And because we are still going according to the plan that we had, I did not foresee that it would collapse completely within 2 days. So I have not consulted with them, but I'm going out to do that.
You see, I'm asking all these questions, counsel, to make sure that eventually, if we are to say a postponement is warranted, we know on what basis we are granting you the indulgence and for how long.
Yes, Chair.
Because, as I mentioned to senior counsel earlier, as you know, postponement is not there for the taking. It's an indulgence.
Correct, Chair.
And we don't have an application in front of us that will inform us as to whether the request should be granted or not. And am I correct that the witnesses that have been allocated to you also relate to the Katomela case?
No, Chair. It's the Mduli case.
The Mduli matter.
Yes.
Have you started? You haven't started at all?
Consulting with the witnesses, no, I have not.
When do you plan to start that consultation?
I will have to contact the witnesses as soon as we adjourn, and then I'll just take it from there, Chair.
Thank you. My sister?
If I may ask, was there any particular reason why you decided to concentrate only on the Katomena witnesses without taking statements from the Mdluli witnesses, not with the aim of calling a witness in the Katomena and then calling a witness in the Mdluli matter and then confusing the record? But I'd like to know if there was any specific reason why you decided to treat them as 2 separate matters to a point that you want to finalize only, you want to consult these witnesses on first before you go to the other witnesses.
I am not sure whether there's really any particular reason, but I may say that, look, having joined these proceedings also in the middle, I found the evidence being led already of Advocate Batohi, and looking at how things were, is that the focus was mainly on the Katomena. Of course, her evidence covered, to some extent, the Mdluli matter, but it seems to us, and when we discussed it, that it would be proper and logical to deal with that part of the case and complete it, and then focus on the other part of the case. I must mention also that with Advocate Koe was given those witnesses for Mdluli, particularly because we needed to give an opportunity to familiarize herself with the information and the facts of the matter. And that would have given an opportunity to do that if things were to happen in the normal way. But firstly is that we understand and we all didn't know what is going to happen now that Advocate Batohi took the decision in December. Number one. Number two, our plan was that we are going to fill that gap so that there's no interruption through these witnesses. That's why my absolute focus, and those witnesses would have, if they were prepared to testify, covered quite a great area of the case, evidence of the case. So we in all reasonableness that we had, we thought that would secure and avoid interrupting these proceedings if we were to secure these witnesses. And all indications from them, and I speak personally because I spoke to them, were that they were more than willing to testify. And they gave me some statement, and as I indicated, I consulted for many hours with one of them. And it was really a sudden and unexpected turn of event when they said they're no longer prepared to testify. To some extent, and I'm not saying perhaps to some extent we are to blame, but essentially what has happened is what we really could not reasonably anticipate or expect to happen, particularly in regard to these two witnesses.
It is, however, correct that when you were appointed, I think Advocate Skosana, Advocate Ngcukaitobi first before you, I think Advocate Ngcukaitobi was appointed before you, correct?
Yes.
And subsequently after you, the junior counsel was appointed. When you were appointed at that time, Advocate Batohi's statement, or a statement under oath, was before you, as it was before us. And that statement encompasses both issues, the Katomena issues and the Mdluli matter, which in my view, and correct me if I'm incorrect, would have given you a start, all of you, those who are allocated to consult, at least to start with some witnesses, junior counsel, especially with relation to the Mdluli matter there. Because the statement was there, the affidavit was there. It is not like everything that surfaced during cross-examination was mentioned for the first time. There were other issues that she raised in her statement which would have enabled you to identify the relevant witnesses. So why is it that that was not done? Just to expedite the matter, I'm trying to understand. Fine, the 2 or 3 witnesses have collapsed, but for the rest, why is it that consultation was not done? I'm just thinking, Advocate Mutlamunyani was leading, and then you have the 3 of you sitting here, And then at one stage you asked to be excused, and I'm trying to think, to understand, why is it that whilst you were presented with Advocate Batohi's statement under oath, little seems to have been done. Very little, it appears. Over a period of a month, maybe I should say that, or closer to a month. And now we have to take a week's adjournment according to your request.
Yeah, well, as far as that is concerned, and may I also indicate, insofar as our juniors are concerned, that's now me with Advocate Mutlamunyane, I fully take the blame that we gave them. I thought that we were going to have these witnesses, and I kind of gave them assurance, taking from the relations and the communication with these witnesses, that really you may consult, but take your time, prepare yourself, but these are the two witnesses that you're going to call, and they may take over this kind of time. So on that basis, I think I take the blame there. Maybe I should have insisted that they must proceed and consult as quickly or as urgently as possible. And that did not happen, for which I profusely apologize. Perhaps we could have done better. But where we are now, we have now this situation where we don't have a witness who can testify immediately. And one must keep in mind that there is also some form of agreement between the parties to share witness statement. In other words, whoever needs to be called next, we need to present a statement in advance for that. So that's another aspect, Madam Chair, that should be taken into account. That in our request for a week is that there will need to be a statement prepared and given to the other team. And I also must mention that while we know that the issue about the evidence of Advocate Batohi started on the 15th of December, and perhaps one could have anticipated that she might not come back, but the developments continued. And if I'm correct, the last development when the minister said finally decided on the appeal was on the 8th of January, if I am correct, which really then started putting more pressure on. Now it looks like the issue of her acquiring that legal counsel that she had asked for is coming to fore. It looks like it's not going to happen, and that might create problems for this inquiry. I just wanted to bring that in, that's one element that must be taken into account, that there is a date of 15 December, which we acknowledge and we accept, but there are quite a few developments that took place that need to be taken into account.
You are stating that what would have caused problems for this inquiry?
No, I was mentioning only that we know that on the 15th, after the 15th of December, there was then an application by Advocate Batohi, although we haven't seen that application, for the appointment of a team, a legal team.
A request. It was a request to the
well, yeah, I said an application, a
to
request,
the state attorney,
yes,
and to the minister.
Later
There was
to
no
the
application
minister.
before us.
Yes. All I was indicating is that issue and the final outcome of that came after the minister had decided. That is now on the 8th of January 2026. And of course followed by what we have now found about the possible conflict of interest as well. I'm just mentioning that those are factors that one should take into account.
So, according to what you've submitted, you interviewed 2 witnesses and they collapsed. We have communication from Major General Boysen, and he says he'll only be available towards the end of February. And then the remaining witnesses have not been consulted.
That's
Now,
that's the essence, yes.
you are here now asking for a stand down, a pause, a postponement. But one can't avoid wondering that what happens after the week that you would have requested, say that request is granted. Would you have witnesses then, or we are going to sit again the whole day having a conversation with the inquiry being put on pause? Because as it is now, you do not have a witness statement that is almost ready. And from your correspondence that we've seen, you were supposed to have exchanged witness statements by the 19th. When was the 19th? Last week, Monday. And it didn't happen. And we are here, today is the 26th. You want us to come back next week, which is February. I'm not sure what is the date next week, Monday. But will we still be in the same position, or the position would have changed? Let us not put Advocate Batohi into the equation, because her issue is a different issue. I'm talking about the evidence leading team and the evidence that they are supposed to lead here through witnesses.
Well, maybe to start with the date of 19 January, that date was not a date on which the parties agree. And I'm not saying it was unreasonable for the Advocate Chauke's team to suggest that date. But we could not agree for the exchange of witness statement. We don't agree, particularly because of the difficulties that we're experiencing with our witnesses. We could not agree to that date. As far as the second question about whether by Monday we would be ready, I have discussed that with my team, and I was given an assurance. Of course, one takes into account that you know, if an individual or a witness says, I can't consult, or I'm not available on this particular date, might create difficulties, but that we will be able to have a witness by Monday to continue in the event that there's still issues about the evidence of Advocate Batohi. Would be able to have a witness to continue with this inquiry on Monday.
Advocate Skosana, maybe let me ask Advocate Mohlamunyani, because you correctly point that when you came, the train was already moving. He was at the helm as the chief evidence leader. I take it, Advocate Mohlamunyane, if you are able to listen as you are moving about. Have you been listening?
I've been listening.
Okay, thank you. Now, I take it that you work as a team, irrespective of who arrived when, but otherwise, as the team was growing, you continued to work as a team. Is that a correct assumption?
It is, Madam Ramagaga. It is correct.
Right, thank you. Now, maybe let us first talk about the witnesses or the persons that you have identified as witnesses to this inquiry. Am I correct when I say that the caliber of persons that you have identified as witnesses and appear on your list of witnesses, they are not lay persons. They are persons who can be assumed to be having reasonable knowledge of what is expected of them. Will that be correct? Generally speaking,
Generally speaking, Madam Ramagaga, that is correct, save for 2 of them. But generally speaking.
Qualifying it with generally, right, thank you. Now, because the main crop seems to be the understanding crop, moving forward, questions that I'll ask will be taking that into consideration. Now, the caliber of those persons is such that they do qualify to assist in developing the draft statements that you would then work on and maybe improve on them in due course. Is that correct?
That is correct, Madam Ramagaga, and perhaps I should indicate to you at this stage, with your permission, what I encountered with my witness, and I'm going to be very direct.
Would you prefer to deal with that first, or should I finish and then you can?
You may finish, Madam Ramagaga.
Right, thank you.
I'll deal with that later.
Yes. Thus far, we are in agreement that they could and they have the capacity to develop the draft statements, which you could then work on and improve on.
Yes, generally.
Thank you. And before you put the names of those persons in the list of witnesses, did you speak to them? And when I say did you, I'm talking about you as a collective, understanding that you are at the helm and you engage and set rules on how to do things. Did you engage? The answer, if it's unison, it will be yes or no. But if each has his or her own answer, you'll answer on behalf of each, indicating that this one has experienced this or this one has not contacted them at all, or so forth. What is the state of affairs?
Let me indicate to the panel, Madam Ramagaga, that I was being assisted by Advocate Hali SC in identifying the witnesses. Mm-hmm. And before I was joined by the team, as you see it, I already had certain witnesses, potential witnesses, who we will need as evidence leaders to come and testify and assist this inquiry. Mm-hmm. After doing so, I then prepared a list. And I must point out at this stage that I prepared that list without consulting those witnesses, without inquiring from them as to whether they will be prepared to testify or not. I was just working on the basis that they are potential witnesses. And in the event that a witness refuses to come and testify, because we do not have, as an inquiry, subpoena powers, we will then inform the panel and our opponents and the Chauke team that such and such a witness who we have identified has reneged on, or has decided not to testify. Now, after having done that, after being joined by the rest of the team, the evidence leaders team, we were then allocated specific witnesses, and I was allocated at General Johan Boysen. I must mention at this stage that General Johan Boysen, as far back as November, December, had prepared draft statements for us. After consulting, after interviewing him and talking to him in Cape Town on or about the 6th of November, if my memory serves me well, 6 November 2025. And indeed, he promised to send draft statements. Indeed, he did so until he gave us a final one. Now, some time ago, a few days ago, maybe 2 weeks ago, I started working on the last draft. And I called him last week and to say to him, General, I'm working on your statement, the last one that you sent to us. He sent the statement to me and Advocate Hali SC. I said to him, I'm working on that statement. I'm trying to finalize and settle it. And I am of the view that you and I should sit in Cape Town. I'll fly down to Cape Town on 2 consecutive days to finalize your statement. We were agreeable about that. I extended an olive hand to him and said, your lawyer or your advocate can be present if she wishes or if they wish. I don't have a problem with that. And he offered to give me, rather, let me correct myself. He asked me as to whether he can give my mobile number to his advocate. I said, yes, you can do that. And then we got into a conversation with his advocate. And his advocate indicated to me that they are working on his statement. Yes, they are working on this statement. I said, I've already started working on that statement. She said, no, we are working on that statement because our client's rights have been trampled on and no one has protected our clients, and our client has to be protected. After speaking to her, I then reverted to General Boysen to say, General Boysen, I'm in this situation. Your advocate is saying 1, 2, 3 to me. Now, I want to find out from you as to whether you would still come to the inquiry to testify. He emphatically indicated to me that he is prepared to testify. He doesn't want to be seen to be a recalcitrant witness. But he has concerns. His concerns are the Danikas issue. The Danikas clips that were flighted on air, and everybody else in South Africa has seen that, and it paints a very bad picture on him, and he wants to deal with that in his fully, decisively, in his affidavit. And he's saying to me that in the course of doing that, he has documentation, some of which is not currently in his possession, is lying around elsewhere, and he still has to get it.
Trying to just indicate that, remember that now I'm not looking for full information.
Yes.
At least you are giving the panel an idea about General Boysen in particular. But the main gravamen of my questions is to check about whether capacity to develop draft statements, and you have illustrated in your address that yes, they are some of them, of course, and General Poison is one of those that have participated in the evolution of the draft statement thus far. That is correct.
That is correct, but
Yes.
with the assistance.
With the assistance of
His
legal
team.
representative, which is fine.
Yes.
Yes. Now, is he the only person that you have consulted with, or from whom you have sought a draft statement, or what is the position?
So far, yes, Madam Ramagaga. That is the only witness that I consulted with, that I contacted, apart from initially contacting Advocate Mlochwa, when I was still alone here. Before I was joined by my fellow colleagues.
Okay, yes,
Yes.
we'll come back to that if necessary. I'm still on the issue of just general questions. Now, the witnesses that you have identified, or persons that you have identified as witnesses to this inquiry, was that list drawn from the names that appear in Advocate Batohi's affidavit or evidence, or are they also constituted of any persons who could have made representations out of interest? What is the position? Is it exclusively from the affidavit, or is it a mix of things? And if it is, please indicate. Thanks.
It is a mix of things, and I'm not able to say which ones have did Advocate Batohi mention in her affidavit. But the majority of the witnesses who are on this list was through the help of Advocate Hali SC, who helped me to identify a witness by telling me that this one is relevant. Look at document XYZ or documents XYZ about this witness is relevant on this aspect. And some of the witnesses I identified myself. But in the main, I was assisted by Advocate Hali SC.
Okay, that's fine. At the beginning, when I started asking you questions, you wanted to talk about whether it's a particular witness or witnesses, remember? Have you addressed that in your answer, especially that long answer, or do you still want to talk about what happened? Yeah.
Not quite. I think I've addressed the issue of Advocate Johan Boysen. I'm sorry, not Advocate Johan Boysen, General Johan Boysen, adequately. He says to me, if I, without being seen to be repetitive, he's prepared to testify, but he can only do so at beyond February, because even his lawyer, his advocate, is indicating to me that that statement will only be available at the end of February.
Okay, thank you. But then you also mentioned right towards the end, you mentioned Advocate Mlochwa.
Yes, Madam Ramagaga, I did mention Advocate Mlochwa.
Yeah. Is there anything that you want to say
About
her availability and draft statements or so?
Let me indicate this at the outset. This inquiry started on the 17th. We started on the 17th of November 2025. And if I'm not wrong, Advocate Batohi started leading her evidence on the Wednesday of that week. On the Saturday, I picked up a phone and spoke to Advocate Mlochwa with a view to find out about his availability for a consultation. The Saturday, the 22nd November. Advocate Mlochwa was more than willing to testify. What he indicated to me as his problem was that he no longer has in his possession his statements. And he asked me to send him his statements that he made when he testified in the Mokoro inquiry and the Zondo Commission. And I made them available to him. He even sent me clips when he was testifying. And I conveyed that to my co-evidence leaders when they joined me. I also indicated that to Advocate Hali. And today, the situation is different.
What is the state? What is the state of affairs? What has changed?
What has changed is what Advocate Themba Skosana has indicated to the panel, that Advocate Molochwa is now giving several reasons about his unavailability during the course of this year. One of his reasons why he will not have time, if I may use that pun, to come over to testify in this inquiry is that, one, he's preparing for the 7th, I think, I'm speaking under correction, 7th Comrades Marathon. 2, he has registered a master's degree with one university, I believe it must be one of the universities in KZN. Another reason is he is saddled with matters, his own personal matters that he deals with as a practitioner. He's now in private practice. He's a member of the Pietermaritzburg Bar in KZN. And that he will be having matters, his hands will be full, so to put it, and he will not be able to assist.
Okay, thank you. So thus far, is the witness, is General Boysen the only witness that you can tell us is available for the Katomena issues? Or is there another one that you can say, as far as I'm aware, this witness or these witnesses are still committed to the cause?
One of the witnesses that I believe is still committed to the cause is Advocate S. Riley, and she has been allocated to Advocate Mutsweni. And I've given Advocate Mutsweni her mobile number, which I asked from the NPA team. And as soon as I believe we leave this chamber, he'll get in contact with her. The next one is the one allocated to me, General Ngcukaitobi, whose evidence, according to what we have, will not be long. And I said to myself, well, this one will not be long. I'll see him later after I shall have dealt with the General Johan Boysen's issue. So I parked it, maybe at my own peril, or at the peril of the panel, the evidence leaders. I just parked it because I wanted to first deal with, because I thought he will not be a complicated witness. But maybe upon hindsight, because I should not have acted in the manner in which I acted. I should have consulted him. Upon hindsight, I realized that.
No, thank you very much, Advocate Mohlamunyane.
Thank you, Madam Ramagaga.
I'm making just a general statement to the evidence leading team. You were appointed by the President to execute your function. And if the witnesses or potential witnesses who are officials in the NPA makes it difficult for you to execute your function, shouldn't you place that in writing and address that to the minister? That we have been given this task, we are not able to perform our function because of this, that, and that, and that, especially the witnesses who are officials or advocates in the NPA.
May I answer, Madam Chair?
Yes, I just want to know.
Yes, you are correct, Madam Chair. that would be ideal. That would be a proper position to take to inform the minister about the hindrances that we encounter. But in this matter, about these two witnesses that Advocate Skosana SC has referred to, one is Advocate Simpiwe Cyril Molocho, who's no longer in the public service. He's in private practice now. I'm not sure whether we can report him to the minister. The second one is Advocate Muiponi Nogu. She's also the former DPP of KZN. In 2012, thereabout, she was appointed the DPP. And as indicated already by Advocate Skosana SC, she was willing to testify, but she has changed colors now. I wonder whether it will be appropriate to report them to the minister. They are no longer in the public service, Madam Chair. Thank you.
Noku
Yeah, Advocate Noku is no longer in the public service. She has resigned.
and Advocate Mlochwa.
Advocate Mlocha is in private practice now. He's in private practice as a member of the Peter Marisbeck Bar.
I'm not thinking in terms of reporting as such, but just placing information before the minister. Because at a critical time, these advocates served under the auspices of the department. Not necessarily that they be investigated, but just to place information for the minister to understand the challenges you are confronted with as evidence leaders.
I agree. I'm inclined to agree with you, Madam Chair.
I may be wrong,
to
but
raise
it's a
the concern.
matter that on your own you can consider.
We will indeed consider that. Thank you, Madam Chair.
Maybe just to add, although they are in private practice, but they are within a regulated space.
Yes, of course,
So,
Madam Baloyi.
so you can deal with them within that regulated space.
Especially that they are members of the LPC, Legal Practice Council. I'm not sure about Noko, but she's still an advocate. She's still holding the title of advocate.
As long as she still holds,
Yes.
she is a member of any legal practitioner in South Africa is regulated by the LPC.
Indeed.
So you can deal with them within that space.
We will do that. We'll consider that. Thank you, Madam Baloyi.
That said, what is your final proposal, Advocate Skosana? I know that you have intimated that Advocate Hali might want to say something,
Yes.
but from your side, what is the final proposal you wish to make to us for consideration?
Madam Chair, our proposal is that we request the postponement or adjournment of these proceedings until Monday, and on the basis that on Monday we should, and perhaps Advocate Harley will touch on that if he's given an opportunity. On Monday, we will have some headway insofar as the issue of the evidence of Advocate Batohi is concerned, number one. Number two, if not, if Advocate Batohi is unable to continue with the testimony by Monday, we will make sure that we have a witness to continue giving evidence before this inquiry.
I'm making an undertaking that if Advocate Batohi's issue is not resolved or she's not able to take a witness stand, you as evidence leaders will be ready to proceed.
Yes, indeed, we are making that undertaking.
Supposedly, you would have exchanged the witness statement in advance with the Advocate Chauke's team.
Yes, Madam Chair, would at least there would be witnesses' statements maybe not all the statements, but there should be a statement of a witness. The witness we would have prepared for Monday will have the statement of that witness. Also
The question
shared.
is whether you would have exchanged the statement that is available with the Advocate Chauke's team in advance, probably on,
Yes.
on Friday. If we are to proceed on Monday with that particular witness, I'm trying to make sure that you are making this undertaking seriously, understanding that the other side must have had a side of the statement.
Indeed, Madam Chair, the undertaking is to also share that statement of that witness in advance before Monday.
Thank you, Advocate Kosana. Thank you, Counsel, all of you. Advocate Ngcukaitobi.
Madam Chair, I suppose there's very little for me to say at this point, other than to ask who.
Do you know Advocate Kosana, or do you have an idea, more or less?
Thank you, Madam Chair. There is no burning desire on my part to say anything per se, other than to explain what our position is. So, what we had requested from the panel, pursuant to a letter which was addressed to you, Madam Chair, as the chairperson of the panel, was a request to allow us to consult with Advocate Batohi while she was under cross-examination in order to advise her. The context to that, much of which has already been canvassed, was that we were initially briefed to act on behalf of the NPA. Those instructions were given to us by the State Attorney, and I imagine that it came from the EXCO of the NPA, which would have included, amongst others, Advocate Batohi. When Advocate Batohi, on the 15th of December, stood down in order to seek legal counsel, her desire was to seek the advice of counsel other than myself and Advocate Ngcukaitobi. We, myself and Advocate Ngcukaitobi, had initially been briefed, as I said, on behalf of the NPA. You may well recall from previous exchanges that we had that I was at pains to point out that we were acting for the NPA and we were not part of the evidence leaders team. At any rate, all of that culminated ultimately in the request by Advocate Batohi to the State Attorney to have the counsel that she wished to have appointed to assist her in giving advice pursuant to the indication that she had given to the panel on the 15th of December. That request, as I understand it, ultimately percolated up to the level of the Solicitor General, who declined to make the appointments. Reasons were given, and the Solicitor General concluded by stating that she had the right of appeal, and she should appeal to the Minister. The Minister was then, after, as I understand it, after some further correspondence was exchanged with the Solicitor General, the Solicitor General indicated that he stood by the decision that had been taken. What then transpired was that Advocate Batohi then appealed to the minister, and the minister's response was that there should be a consultation, that she should rather seek the advice of myself, of me, and Advocate Ngcukaitobi. After considering the correspondence, we decided to write to the panel, as I've indicated, to make the request to the panel that we should be allowed to consult with her, because it was anticipated that we would need to consult on matters that may well involve issues that were canvassed during the course of the of cross-examination. Now, subsequent to that, and nearing the present date, it became, I certainly had occasion to reflect upon this, and how would I be able to consult with her, and how would I be able to properly address some of the issues that were reflected in the request to the state attorney. It seemed to me that it was inevitable that a conflict of interest was going to arise on the one hand between Advocate Batohi and the various options that may confront her, and the NPA. Bear in mind that my brief came to me to represent the NPA, not to represent Advocate Batohi, and that her request had been made initially for other counsel to represent her. Now, it was in that context that we approached the panel this morning and indicated that we believe that we are heading inevitably towards a conflict of interest. We would not be able to properly discharge our mandate to either one of those clients, to be able to canvass every aspect that was in the best interest of either one of those two clients. Now, at the moment, we are unable to take instructions from our client, which is the NPA. Until now, our client has been represented by Advocate Batohi, as well as the EXCO. So where necessary, I've had to take instructions from the EXCO. But since the latter part of last year and the early part of this year, that EXCO has been somewhat denuded of some of its members. Some of the members have fallen away. They've either resigned or retired. I stand corrected. I don't know which. And at least two of them are simply acting members. So the upshot of it all is simply that they are unable to provide me with instructions, even if they were desirous to do so. It's possibly in the context of that, having explained it to the evidence leaders, it's possibly in the context of that the suggestion was made that we should stand down until Monday, because Monday is the date on which the new National Director of Public Prosecutions takes office. But I don't anticipate, and I don't wish to comment necessarily on the stance adopted by the evidence leaders, but I certainly don't have the confidence necessarily, because I simply haven't spoken with the new National Director of Public Prosecutions, whether he would even entertain my presence on Monday. So that's something that still has to happen. So I can't give any undertaking as to when that would happen. My experience, having worked with different organs of state and different departments, my experience has always been that I'm going to be requested to provide some kind of a memorandum in order to bring the individual who's going to have to take the decision up to speed. I anticipate that that would happen with the new National Director of Public Prosecutions. To put together, and of course at this stage I simply haven't been asked to put together anything, not a memorandum or otherwise. So I'm still hoping to get an audience with the new National Director of Public Prosecutions. I might be, I'd like to think that I would be a priority for him, bearing in mind the circumstances of this matter. But I'm simply, as I haven't spoken with him and I'm not in a position to comment either way. So that's the position where we find ourselves in, and my position applies equally to my junior Advocate Ngcukaitobi. There was a question that was posed, if I recall correctly, by Advocate Batohi Mary as to whether, when the minister had been approached, had she been approached about the potential conflict of interest? The short answer to that is no. But there were certain aspects of the minister's letter that I thought may require me to revert to her, if I was permitted to do so. The one concern that we had when we considered whether we ought to go back to the minister was we had no understanding of the regulatory framework that gave rise to the minister's position as the appeal body. So we read through all the legislation, the State Attorney Act, we read through the regulations, and we read through the through the policy that we had been referred to. We were unable to find any particular document or instrument that could talk to the question of whether the minister was functus officio, as it were. So we did consider the possibility of going back to the minister, not specifically on the question that was raised, but on certain other aspects of the letter. But that's as far as we could take it. That's where we stand at this point in time.
Now, given the fact that a decision has been taken already by the minister, assuming she had no power to decide on the matter, if she's functus officio, but a decision has been taken, will there be any harm in you and your junior or even the NPA presenting this difficulty to the minister that you anticipate? Because as I understand the correspondence, the minister decided on the basis that you and the junior are here and you could represent Advocate Batohi at a personal level. That's how I understood.
That is correct, Madam Chair.
Yes, the correspondence. But if the minister is to be advised that the converse is true, you are actually not in a position to represent her because of this potential conflict, a matter which was most probably, as I understand now, not brought to her attention. That might just resolve this whole conundrum. And the minister may revisit whether she is functus or not. She may just maybe reflect, or the Solicitor General himself may even reconsider the position and decide otherwise.
Madam Chair, it can't do any harm to revert to either one of them. It would seem to me that given the level to which it has advanced, the appropriate person, if we are to go back, the appropriate person to go back to would be the minister now that she's seized with the matter. As I said, this issue arose, the question of the conflict of interest arose fairly recently. So up until last week, it wasn't always apparent to us that there would have been a conflict of interest. It was upon reflection that we came to appreciate that there would be a conflict of interest.
Yes, and if I may guide.
But I take your point, if I may conclude, I take your point.
Yes,
and certainly during the course of the debate between the panel and the evidence leaders team, it struck me as being a rather sensible approach to adopt.
Council, if I may guide, if you may consider that approach, that the new NDPP has not taken office as yet. As we speak, Advocate Batohi is still the NDPP. And also given the fact that these are polycentric issues that will entail a decision made or to be made by a member of the executive. You know, when you talk money in government, especially because the NDP or NPA falls within the auspices of the department, of the ministry. Am I right?
So
I'm not sure whether I'm putting it correct, but it is an institution in respect of which the NDPP works hand in hand with the Minister of Justice.
That is so, my lady. If I understand correctly, functional responsibility ends at the National Director of Public Prosecutions, or operational responsibility. But insofar as the responsibility for finances are concerned, that responsibility ends with the Department of Justice.
Yes. The issues that we are dealing with now concerns finance, budgetary matters, and the minister seems to be the right person to go to insofar as Advocate Batohi's request is concerned. So if it is discovered, as you'll be talking to one another, that there is a conflict of interest, a matter that might not have been brought to the table of the minister, or even the Secretary General, Solicitor General.
The Solicitor General.
The Solicitor General may reconsider, the minister may also reconsider, and we may not even be here now. We should have made a headway. So it seems to me that on the challenges that you and your junior are confronted with, which is quite understandable, perhaps now that the minister has decided that you must represent her or consult with her, and you are now confronted with all these sorts of legal challenges, because even if you were to be appointed to represent her, the question that then arises is whether you have a right to consult with her on matters that arise during consultation, cross-examination. That opens all other difficult challenges, as you know. So it seems to me that the buck stops with the minister. And if she is to appreciate these challenges that you are placing before us, she may just as well decide otherwise. A week, I'm not sure, but it seems to me that the first person to communicate with is the minister, because the new NDPP has not assumed office. Advocate Batohi, you cannot talk to her. She's the NDPP, but because of these issues that you are grappling with, you cannot talk to her. And the minister is the last place to go to if the Solicitor General does not give you out and he thinks that you are not entitled. I'm sure you'll start there, and then the matter will then go to the minister. He's here, you can discuss the matter without necessarily having to write letters to each other. And I'm sure the Solicitor General appreciate the very challenges that you are presenting to us. No, thank you. I'm not sure whether my sisters would like to ask you any question.
I have just one. I'm sorry, I thought I would keep quiet because it's late in the day, but I can't help myself. You painted a picture that it seems like literally EXCO within the NPA does not exist anymore. You said some have left and some are acting. Two.
Two of them are acting. That is
are acting. And how many have left?
If I understand correctly, one is left, and Advocate Batohi is the other one.
Yeah. How many?
I think there may be one vacancy. I think there was supposed to be 4. I stand corrected. 4 Deputy National Directors of Public Prosecution, all of whom would be ex officio members of the executive. 2 of those are acting. 1 is left, and I think there might be a vacancy. I can take instructions.
And then there's Advocate
And then there's
Batohi.
Advocate
So it
Batohi.
means you only have 1% or 2. So they
We
can
only
never
have 2
correct.
acting appointments.
Yes, they can never correct.
They can't correct, and even if they were correct, I would be very surprised if they would take a decision of this nature.
If they would take a decision. So what you are literally saying to us is that you are now sitting here without anyone giving you instructions. You are sitting here. You since received your instructions right at the onset, and as we go along, you don't have.
Well, sometimes when the head has been chopped off, the body continues to operate even despite the head being absent. But but in this case, that's not the case, because management, you still have a manco, you still have the rest. I mean, the operations continue despite the problems that may confront the EXCO. Thank you, Madam Baloy, Mary.
Yes, wait. Advocate Hali, on the issue of the EXCO, I'd like to establish maybe what circumstances or the process leading to your appointment to represent the NPA. Now, or the recommendation for the state attorney to appoint. I get there's a process. So what I'd like to establish is whether the decision to recommend that you be appointed to represent the NPA, did it come from EXCO, or did it come from Advocate Batohi as the head of the institution, or what is the position? Because that information will assist us to weigh on what you have just informed us of, that the EXCO, the NPA EXCO, seems to be dysfunctional or paralyzed because of other reasons outside their control. If he doesn't correct, we understand. If he doesn't correct, it would not make decisions or whatever. Whatever the case is, that is actually paralyzing that body in particular.
Thank you, Madam Ramachaki. I mustn't be seen to be saying that the EXCO is dysfunctional or that it's impotent at the moment. I'm not saying that at all. I think it's specifically in relation to this issue. I would imagine that in relation to other issues, Advocate Batohi would be quite competent to continue to take the helm. It's specifically in relation to this matter. But in relation to the question that you posed to me about how I was briefed, quite frankly, Madam Ramachach, I actually don't know. All I know is that I get a brief from the state attorney, and in the context of this, it would of course be preceded by a telephone call. Am I available for this? Because I have been involved in the matter previously, as you would be aware. But it's in that context that I get that I would have been briefed and asked to respond to a request to participate.
So it will be fair to say you will not know as to whether it becomes necessary or it is actually necessary for MENCO to sit and agree about a recommendation for the appointment or not.
So are we talking about MENCO or EXCO?
EXCO, I beg your pardon. Is it EXCO, MENCO?
So
Let
EXCO
me
is...
just place it on record because I may have used it interchangeably, that whenever the record reflects EXCO or MENCO,
Yes.
I'm using the term interchangeably.
Very well.
Thank you.
Yes, okay. So we're talking about EXCO. My understanding is that that decision is one that has to be taken by EXCO.
Okay,
That's my understanding.
right. Okay then, thank you.
Thank you, Madam
Thanks.
Ramachach.
And which decision is this, by the way?
Pardon?
Which decision is this, by the way?
To eliminate the possibility of a conflict of interest, so that if the whatever decision is taken ultimately by Advocate Batohi, to allow that the NPA accepts that the fortunes of the two are inextricably tied and that they would go with whatever decision, so I can advise both of them. And the advice I give to Advocate Batohi would be the advice that the NPA would accept. You made the point early on, Madam Chairperson, about approaching the Minister / the Solicitor General of the various options that that confront me, or the various options that suggest themselves to me. It would strike me that that's the most simple of the two options, which is to approach the Solicitor General or the Minister. It's something that could resolve the issue much quicker than the other one.
Councillor, that seems to be the better approach given the circumstances. But you'll weigh your options and you'll indicate finally to the Minister what your challenges are. And I'm sure the evidence leading team will do the same.
As it pleases you, Madam.
Yes, thank you. Thank you very much for apprising us of all this information, and hopefully you will be in a position to execute your mandate, your initial mandate, and proceed to assist as you have been doing. And if a potential conflict is or arises or has been found, the team will take appropriate steps. What those steps will be, we have engaged with all of you, and you'll decide how to approach the matter.
Thank you, Madam Chair.
We need a few minutes to confer with one another regarding the requests that you've placed on the table. We will reconvene in 10 minutes. 15 minutes? 22. At about 20 to 6, we will reconvene. give a direction.
Thank you, Madam Chair. Whilst I've got the mic, and it's been a long time since I've had the mic, I may as well make the most of it. What Advocate Batohi has communicated to me just before she departed was that she was going to have some difficulty coming back this week. She's got meetings with various people, including the President, in the forthcoming days. So she's asked if she can be excused. It seems like it would be inevitable that she will be excused anyway, but that she not be required to return whenever we get to, whether it be on Tuesday or whether it be on Friday. But whatever decision is taken, if she can be excused, and then I can communicate that to her through one of her assistants who's here tonight.
Advocate Halley, it doesn't appear to us that there's anything that can really be done given the circumstances. Even if she were to attend, she wouldn't be testifying, pending the determination of the very issue that
Indeed.
has given rise to all these debates and exchange throughout the day. Yes, she is excused. I'm sure by Monday she will be here.
Thank you, Madam Chair.
Yes, thank you. We will adjourn until 20 to 6. Just give us 15 to 20 minutes to decide, and we will come back. We'll adjourn. Thank you. Good afternoon, everyone. Our apology for taking a little longer. There were some few other matters that we needed to consider, given the request for a postponement to next week, Monday. We have drafted a very brief ruling which read as follows. The evidence leading team applied from the bar for a postponement of the inquiry for a period of a week, that is until Monday, the 2nd February 2026. The request is made because of two issues that have arisen. The first, concerning a potential conflict of interest between the NPA legal team, namely Advocate Hali SC and Advocate Ngcukaitobi, and their proposed role to represent Advocate Batohi. Advocate Batohi had unsuccessfully requested the Solicitor General to appoint a further legal team to represent her. She was advised of her rights following the refusal by the Solicitor General to appeal to the Minister of Justice and Constitutional Development. Advocate Batohi did appeal the decision of the Solicitor General. On or about the 8th of January 2026, the Minister advised Advocate Batohi to use the services of Advocate Hali SC and his junior, Advocate Ngcukaitobi, who, as I have mentioned, have been instructed to represent the NPA. On or about the 9th of January 2026, Advocate Hali addressed a letter to the panel requesting to consult with Advocate Batohi following the decision first by the Solicitor General and subsequently by the Minister as mentioned in the letter. The consultation was to cover aspects that Advocate Batohi was testifying on whilst under cross-examination. Advocate Chauke's legal team wrote signifying their intention to oppose the request to consult with Advocate Batohi whilst under cross-examination. The evidence-leading team seeks to confer with the State Attorney with a view to establish whether such potential conflict of interest exists, and if so, what appropriate steps they should take. During engagement with the evidence-leading team, in considering the request for a postponement, it emerged that neither the Solicitor General nor the Minister had been apprised of such potential conflict of interest. Therefore, the team requested time to consult and make an assessment whether such conflict exists. The second issue giving rise to the request for a postponement concerns challenges with potential witnesses, especially in relation to the Katomena matter. Seemingly, some of the witnesses who had been identified and had been consulted with have now withdrawn their availability. Other witnesses, including those with regard to the Mdluli matter, are yet to be consulted by the evidence-leading team. The request for a postponement made from the bar necessitated varied questions from the panel because a postponement is not there for the taking. There can be no doubt that the request for a postponement for a further week will cause a further delay in finalizing this matter, or rather with making progress in relation to this matter. Thus far, only one witness, Advocate Batohi, has testified and is still under cross-examination. Having considered the request and the submissions made by the legal teams, we agree that a postponement is, under the circumstances, warranted. However, the request until Monday, the 2nd of February 2026 cannot be granted because such a postponement to that date will go beyond the period allocated by the President for the inquiry. It must be mentioned that the request for extension of the period allocated has been made to the President, and the panel still awaits the decision from the President in that regard. It must also be mentioned that the evidence-leading team has made an undertaking to provide the witness statements to Advocate Chauke's legal team by Friday, the 30th of January 2026. The further undertaking was that the inquiry will proceed without further interruptions. Accordingly, the matter is postponed to Thursday, the 29th of January 2026. 2026. And we request all the parties to be here on Thursday, the 29th of January 2026. We so order.
As you please.
As it pleases.
We will adjourn until Thursday, the 29th of January this year.